Good afternoon, everybody, and welcome back to Hunt Law Firm's latest installment in our series of live Q&A sessions on a wide range of issues in Texas family law and the issues affecting you. My name is Alex Hunt, and I'm the founder and managing attorney at Hunt Law Firm. We serve clients in Katy, Cypress, Harris, Fort Bend, and Waller counties, and the entire greater Houston area. Our practice is dedicated to family law, divorce, and child custody issues. Today, I'll be joined by Hunt Law Firm Senior Associate Attorney Melissa Masoom, and we'll help you dig through the facts and the fiction of some more recent issues in Texas family law, particularly some new questions and misinformation that has arisen as a result of the COVID-19 public health crisis. Now, we've already received some questions beforehand, but we'll also be happy to take your questions live if you have them, so just leave them in the comment section below. And if you know anybody that could benefit from the information that we're providing, you can share this video and hopefully they can hop on and join us. We're going to be presenting some timely and useful information that folks are dealing with in these challenging times, as well as taking your questions. And of course, today's video does not create an attorney-client relationship and should not be taken as legal advice. Because everyone's circumstances are unique, your attorney would need to know the particular facts of your situation to be able to provide legal advice. Instead, these videos are really meant to be educational and informational, and perhaps a starting point for some big decisions that you may see on the horizon, or perhaps you just want to learn a little bit more about Texas family law. You can take a look at our previous videos on a variety of different family law related topics on the videos tab of our Facebook page at facebook.com/huntlawtexas. And at our website at familylawyerkaty.com, and then click the Our Videos link at the top of the page. Keep in mind, too, we're 100% staffed and operational. We're continuing to serve our clients throughout the stay-at-home order, and we're offering telephone and video conference consultations to serve you. You can find us at 832-781-0320, and of course at our website, familylawyerkaty.com. So today I'm happy to be joined by Melissa Masoom. Melissa is Hunt Law Firm's Senior Associate Attorney. She has a wealth of experience in both civil trial law and family law. And today her practice is focused entirely on family law here in the greater Houston area. Good afternoon, Melissa.
Hi, Alex.
All right, so let's jump right in. We're going to do some fact or fiction, particularly around some of the issues that are surrounding COVID-19. So the first question for you, fact or fiction, I can't get divorced or open a child custody case right now.
This is fiction. So there's nothing stopping anyone right now from e-filing a new case, and courts are still accepting and routing new filings. So in fact, we're filing several new cases here every week and getting court settings if needed. So courts are not completely closed.
Okay, so people can open a new case. Will they be able to get anywhere in that case? Are they going to be stuck in the mud until the stay-at-home order is lifted?
So they will, Alex. So once we file, we have a few options to get your case moving. We can try and resolve it informally, if that's an option. We can also schedule a mediation, even if it's just for temporary orders. We can also make a case by doing what's called formal discovery and information gathering, basically. So most courts require mediations anyway before going into court. So we would do all of that before anything else.
All right. Well, it's a fact or fiction. The courts are still open despite the stay-at-home order.
So yes, they are open. So the Texas Supreme Court enacted 7 emergency orders affecting all the courts in the state of Texas. And those began on March 13th and are lasting right now through May 8th. So they might be extended. Individual courts around Texas, including Fort Bend, Harris, and Waller County, have made their own standing orders that modify these orders. And what they do is these standing orders actually modify and suspend the deadlines. They allow remote appearances for proceedings, such as by video or phone. They have rules in place to consider testimony or evidence offered electronically, conduct proceedings away from its usual location in the county, and they take any other reasonable actions to avoid exposure to COVID-19. So with all that being said, it's important to note that most courts in Fort Bend, Harris, and Waller are prioritizing emergency cases, or what they're calling the essential cases.
Okay, so could you explain a little bit about what qualifies something as an essential case?
So Harris and Fort Bend both put some guidance out as to what essential cases are, and those include protective orders, so cases involving any kind of family violence, CPS hearings, enforcement, habeas corpus, writs of attachment proceedings, so cases where one parent is refusing to turn a child over. Also, temporary orders with what we call extraordinary relief are also being heard. The courts also left it open so they can determine what is essential on a case-by-case basis. So we are getting some things heard that aren't actually covered on the list, but need to be heard right now.
And you mentioned hearings via video and phone. I know some courts are doing Zoom. And I know that we've put, myself and yourself included, a lot of time into our blog entries at familylawyerkatie.com. And then you click on blog, we have information about what the particular courts in the greater Houston area are doing. But are all of the courts in our area doing these video and phone hearings?
Right now, Alex, I'd say a good number of Fort Bend and Harris County courts have implemented some sort of procedure for either telephone or hearings via Zoom. All of us here at Hunt Law Firm have been doing them over the last month or so. I expect that more courts will do the same over the next few weeks if these orders are extended. Okay.
Our next question, fact or fiction, and I think a lot of our viewers probably know the answer to this, but we're in a pandemic. Fact or fiction, I can withhold my child from the other parent if I feel like it, right?
So we get this question a lot. So that's definitely fiction. If you have a court order in place and you don't let your kids go to the other parent per that order, you're violating that order. So the order is in effect until you go back to court and you have the judge modify it. You should review your order and see, what your possession order actually says, and speak to an attorney before you decide to do anything.
So we have a lot of clients, and we've had, prospective clients that have called us, and they have a real fear of how safe the other household is, whether they're taking precautions, whether they're following the guidelines put out by the county and the state and the federal government, and they're afraid that their child's going to be exposed. What would you suggest for those folks?
So same answer. You still need to go to court. If you withhold the child, you can be held in contempt of court. But you do have a duty to protect the child and their welfare. So if you feel the child is in danger, you may need to talk to an attorney again about your options and the specific details of your case, because your withholding might be justified, but you do need to talk to someone to see what the consequences of that might be. So either way, you should document everything, keep a record of everything if possible, just in case you do end up in court.
Okay, so let's take the flip side of that last fact or fiction. This time, fact or fiction, if the other parent withholds my child from me, there's nothing I can do.
That's absolutely fiction, Alex. If the other parent is withholding the child and violating a court order, that's most likely an essential case. In an emergency situation, a court will probably hear this case as soon as possible. You'll need to bring an enforcement action as soon as you can and hold the other parent in contempt of that order. So I always recommend, though, to try and talk to the other parent about your concerns and try to work out a solution without an attorney or the court, and figure out something that allows for the child to stay safe and healthy. But if the other talking to the other parent doesn't work, which sometimes it doesn't, the danger to the child is immediate. You need to call the authorities and keep record of everything, talk to an attorney, and then hopefully something moves forward.
Okay, let's shift gears again. We talked a little bit about child custody and how it's related to COVID-19, some new issues that have arisen. Big part of divorce is the financial aspects. Most folks will either rent or own a home. So fact or fiction, even if we do a divorce and we finalize it during COVID-19, I can't sell my home or buy a new home during this pandemic.
So that's fiction. We learned a little bit about this in your Q&A last week with Tim Socher from Tim Sell. So real estate is actually deemed an essential business. So realtors are still doing their thing. Mortgage companies are still doing what they need to. But, you still have to comply with local orders, such as wearing masks when you go see a home, et cetera. So I've actually spoken to a number of people in the real estate business that told me that there are still mortgages going out, they're being approved, and people are still buying and selling homes right now. We're not in a recession, so the homes are actually, there might be less out there, but people are still doing what they need to get out of their homes. And if you're in a divorce, you have some options.
So a lot of our clients are in this situation, and they have a marital home that they need to unload, and perhaps they're going to split the proceeds, or it's going to go to one party or the other, but they don't want folks traipsing through their house during the pandemic, masks or no masks, and they don't want folks coming in to their home for showings. Can they wait until after the divorce is finalized to sell it?
Absolutely. So something a lot of people don't realize is that they can get a divorce and agree to sell your property at a later time. So you put in all those provisions into a final decree. You can do it by a certain date, or you can do it once, something happens, a condition is met. And this is usually an ideal option for people right now who want to wait until things settle down. The market is maybe up again, or whatever needs to happen for them to actually buy or sell a new house. And as divorce attorneys, we do this option often, even before COVID-19 came around. We draft divorce decrees, and it allows people to sell their home later and agree to how those proceeds will be split and have options in case circumstances change.
Okay, another financial question, and one that's on a lot of folks' minds because the federal government passed what's called the CARES Act, which provides for a stimulus check to most families. A question that we've got: I'm already divorced, fact or fiction, I just got the stimulus check for both me and my ex-spouse. I get to keep it in its entirety, right?
Wrong. That's fiction. So the CARES Act actually says in relevant part that in the case of an eligible individual, there shall be allowed as a credit, and it's $1,200. So when they say individual, we as attorneys read that as individual. So a portion of the payment you receive actually belongs to your ex-spouse, the other individual that it's for. So if you've received it, it's highly recommended that you forward the funds to your ex-spouse as soon as possible, and the amount has to be provided to your ex-spouse as an individual. And by keeping the money, you might face some consequences and violate federal law. So it's what we recommend.
So what if you're on the other side of that transaction and your ex-spouse is the one that got the stimulus check, or they got the direct deposit? What can you do?
So if your ex-spouse has kept your check, you probably need to contact an attorney, and you need to see what your options are. This also includes, Alex, any portion of the check that is for the children. If you're the custodial parent and the other parent received the $500 for each qualifying child, you'll need to speak to an attorney. And you're actually going to be talking to an attorney that's an expert on all this, Lucy Petrie, on Thursday. So if everyone tunes in on Thursday at 1 p.m., you probably will be answering some more of this with Lucy.
Yeah, definitely. That's a great question for her. Okay, next question, fact or fiction? I've lost my job due to COVID-19. I don't have to pay child support. I don't have any income coming in.
So the bad news is that this is fiction. The good news is, though, that you can modify your child support amount based on material and substantial change, and that includes unemployment or a significant loss in income. So it's very rare that a court will say you don't have to pay any more child support, or your child support obligation is suspended completely. But you can at least try for a reduction. The most important thing about this is that you need to file as soon as possible. You need to file a suit to modify your child support. And then the date of modification will be the date that the court's going to consider retroactively changing the amount of support. So you can get that fixed retroactively, but you need to do it as soon as possible.
Now, if somebody does file to modify their child support, or they have a child support conference at, say, the Office of the Attorney General, or child support hearing set, are those going forward at all, or are they waiting until after the stay-at-home order is lifted?
They're actually going forward differently. So many of the local child support offices are actually closed at this time, and you can find out which ones online. But the good news is that the Office of the Attorney General actually they've begun virtual negotiations. So you have to log on to your child support page and request a virtual negotiation for your hearing. And so if you actually have a hearing scheduled that's in court, you'll need to talk to the OAG, the Office of the Attorney General, and see how that particular court is handling child support hearings at this time. But, it's good news. You can still get something done. According to the Attorney General's page, they're still going forward and modifying child support at this time.
And another important note is there is something folks can do if their co-parent isn't paying child support and should be, right?
Right. So if you're the custodial parent and a non-custodial parent is not paying their child support, you can bring an enforcement, and you can contact an attorney or the Office of the Attorney General and get that filed as soon as possible.
All right. Well, thanks very much, Melissa. That's all we have time for today, and thanks so much for joining us. If you found this video helpful, please hit the like button. If you thought of somebody who could use this information, then please share it with them now. We'll be back doing another live Q&A this Thursday. You heard Melissa mention it, with Lucy Petrie. Lucy is an MBA, a CPA, and a Houston area tax attorney, and we'll be discussing the intersection of family law, divorce, and everyone's favorite topic, taxes. And so remember, if you need legal representation on a family law matter, you can find us at familylawyerkatie.com. That's familylawyerkatie.com. My name is Alex Hunt. For Melissa Masoom and the entire team here at Hunt Law Firm, thanks for joining us, and have a great day.